Hi, today I am going to share with you a very important Supreme Court judgment between Satinder Kumar versus CBI. So this judgment is against, or this judgment works for disciplining the powers of the police. This judgment works for tuning the powers of the police, tuning the discretion of the police. What exactly happens is, whenever the police receives a complaint against an accused, they spring into action by threatening the accused, which are the remains of the colonial British era, by thrashing the accused, by beating the accused, by creating fear into the mind of the accused. So therefore, earlier Supreme Court made it compulsory to issue 41A notice through Arnesh Kumar judgment to tune the powers of the police. What is 41A notice? It is a simple notice issued by the police after registering the FIR against the accused, notice issued against the accused, asking him reason why he should not be arrested. Asking him reason about the nature of the crime. See, the point of Arnesh Kumar judgment of the Honorable Supreme Court is that if the accused is available for investigation, what is the purpose of arresting him? Issue him a notice. If he is available for serving a notice, there is no point in arresting the accused. If he is not available for serving the notice, if he is absconding, generally whenever crime is committed, the default action of the accused is he absconds. So when he is available, what is the need of arresting him? What is the need of burdening the courts with the bail applications? What is the need of violating the Article 19 and 21 of the Constitution of India, which speaks about freedom and right to freedom and right to life, right to liberty? What is the need of disturbing those rights? So Supreme Court, through Arnesh Kumar guidelines, made it compulsory to issue 41A notice for the crimes which are inserted in the FIR, which have a punishment of less than 7 years. For example, cheating has a punishment of 7 years or less than 7 years, depending upon the magistrate's discretion. Even though Arnesh Kumar guidelines were issued, police could not be controlled. Police action, police arbitrary action could not be controlled. Therefore, now Supreme Court has come out with another decision that if the procedure that is applied for issuing 41A notice is not followed by the police, listen carefully, if the procedure that is given in the Arnesh Kumar guidelines of the Honorable Supreme Court, where 41A notice is compulsory to be issued for crimes that are registered which have a punishment of less than 7 years, then it will be a ground for bail. So there are many grounds for bail. The many grounds for bail are the flight risk, the tampering with the evidence by the accused, pending investigation, etc. There could be the grounds for the bail which are opposed by the state or the public prosecutor, which are taken by the public prosecutor of the state. Now, with this judgment, Supreme Court made it clear that if 41A notice procedure is not followed, or if the guidelines of the Arnesh Kumar judgment are not followed, then it will be a ground for bail. So whenever you find that police are trying to be arbitrary against you, immediately you can apply for bail, and that will be a ground for bail. Forget about other grounds. If you could prove that 41A notice was not issued, or the procedure that is prescribed in the Arnesh Kumar guidelines was not followed, then it will be a ground for bail. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.